Good afternoon, everyone. My name is Asterios Tsioummanis, and on behalf of the Transdisciplinary Institute for Environmental and Social Studies, I welcome you to today's seminar. I will be sharing my screen for a couple of minutes to introduce our seminar, and then to introduce also our speakers, and then we'll continue with the main part of our work for today. So we have a 3-year project financed by the Erasmus Plus program of the European Union under the Jean Monnet program, and it's focusing on environmental rights, on the intersection between human rights and the environment. The project has 5 dimensions. Just give me a second, we have a small technical problem. So here we go, that's much better. So the project is entitled Human Rights and the Environment in the EU. It tries to analyze the intersection between human rights and the environment. It's a 3-year project, and it's moving along the projections. We have 5 thematic entities, as you can see here. The green ones, the fundamental right to the environment in the EU, the introduction of our work, and the human rights and the conservation and sustainable use of biodiversity have already been done and are available in our YouTube channel as well as on the project website. And we have 3 more to go. The third one is today's seminar, which focuses on intergenerational rights, including children's rights and the environment. And then there are 2 more, as you can see here, human rights and climate change, which will take place sometime towards the end of June. And then challenges in practice, which will focus on specific cases of environmental violations of human rights related to environmental degradation that will take place in Thessaloniki sometime in late September. The last one, the challenges in practice, will be the only one which will actually take place in person. All the other 4 seminars, we decided to do them in a hybrid version or in a virtual version. It started like that because of all the COVID-19 related restrictions, and then since these are all equal pillars of the project, we decided to give them equal standing. So we follow the same format for these 4 seminars. So to go to the main event for today, we're focusing on intergenerational rights, including children's rights and the environment. And we have, in this section, the project has 3 contributors. Today, we're going to have with us 2 presenters. I'm going to quickly introduce the first of them, and then I'm going to go over the first presentation, and then we'll have a quick round of discussion, and then at the end, we will move to the final round of the second presentation and the final round of discussions. So we have 2 presenters with us today. First of all, it's Ivana Savić. We're very glad to have her with us. She will address the concept of intergenerational rights from the perspectives of international law as well as EU law, focusing on obligations of various actors as well as challenges and opportunities for realizing environmental rights, and including for children, domestically, regionally, and internationally. So Ivana is a recognized human rights and sustainability expert and has more than 14 years of experience in international development, including environmental sustainability, also in sectors like energy, human rights, policy, and law development. She has a wealth of experience in designing processes and building architecture for human rights and sustainable development, and a proven record for generating transformative changes and innovative solutions. Especially, she has taken part especially in the process leading up to Rio +20 in the adoption of the UN Sustainable Development Goals. Ivana is also an external Ph.D. candidate at the Institute of Private Law at Leiden University, with the research topic being international environmental rights of the child. So we will really appreciate her expertise, and we are very glad for having her today with us. So up to you, Ivana.
Hello, good afternoon, everyone. So I will start with my presentation, just a sec. So today I will be presenting intergenerational rights, and we will explore this critical topic that concerns the well-being of both current and future generations. But the focus will be on children and environment. And in this presentation, we will delve into the concept of intergenerational rights, their significance, and the role of each of us playing in ensuring a sustainable future. We'll start firstly with the problems of the human environment, because understanding the problems of human environment is crucial for understanding and addressing the intergenerational rights of the child and environment. Because the problem we face today, such as climate change, deforestation, different types of pollutions, have far-reaching consequences, and intergenerational rights actually emphasize the importance of the equity and fairness between different generations. It also underscores the need for sustainable development and sustainable development solutions and practices, and also recognizing and addressing environmental problems demonstrate our responsibility as stewards of the planet and life-supporting systems for all humans. Environmental problems are complex and interconnected. Climate change, for example, affects various aspects of human and natural system, from food to public security, but also financial systems. So the notion of problem of human environment here is understood to mean, this is actually adapted version from the letter from Sweden to the UN when they introduced the idea of organizing the Conference on Human Environment Stockholm in 1972. The concept has two problems, basically. The problems of human environment has two problems with it. The first problem is changes in natural surroundings brought about without adequate control by use of modern technologies and advances in industry. And then we have the second problem, which is how it impacts humans. And these two problems manifest in different ways. So the firstly, we have increased air and water pollution and erosion, excessive and controlled use of biocides, and etc. And also because the climate change was not an issue in 1968, we can now add also the issues of climate change. And then the second problem manifests as the living and working conditions, and also unplanned and uncontrolled urban growth, and etc. They nicely formulated actually how it's impacting the interconnection between human rights, human issues, actually social issues, political, economic issues, and also environment. So we can see how actually environment can influence negatively individuals, but also society as a whole. And this actually explains the complexity, interconnectedness, and like environment shapes humans and human society, so human society shapes the environment. This brings us to the next question, is basically the tension between the present and the future that arises due to competing priorities, interests, and timeframes. So here we see that it involves making choices and trade-offs between immediate needs and desires versus the long-term well-being of the future and present generations. The key factors contributing to these tensions are short-term versus long-term benefits. Then we had the issues immediate gratification versus deferred reward. Then we have limited resources and capacity, whether we meet the current needs or we plan for the future, how do we do it? Then we have also issues related to uncertainty and discounting the future. But also the important aspect of these issues is also the issue of intergenerational justice and equity. Which brings us to the next slide. What are the intergenerational rights and why they matter? They're actually quite complex. And on the one hand, we have the present generations, and those are basically present generations that are living right now. But also within the present generations, we have different age cohorts with different interests and with different priorities. On the other hand, we also have the urge to procreate and to be creators, and creating the conditions and circumstances that suit our desires, or in the words of the Agenda 2030, to create the future we want. So we have also the concept of the future generation and the concept of future. But in between those two, we just don't wake up one morning and say like, we are in the future. We have the period of transition. And basically children are those who are in that transitioning, let's say, phase where they're not fully present, but they're also not in the future. And without actually going into discussion when the life starts, when does the future generations begin or end, whatever. Here it's important to mention that actually one of the main concerns now is also that, according to one of the reports of the UN Special Rapporteur on Toxics, majority of children nowadays are born already pre-polluted, which points out that environment has quite adverse effects, not only on rights, but also on well-being, health of children, and also their ability to survive and develop, because we also have the reports of the World Health Organizations and other UN entities saying that children below age of 5 are five more times more affected negatively. Or actually, their morbidity is 5 times more higher than morbidity of adults due to environmental burden of diseases. So when discussing the concept of intergenerational rights, it also involves discussions on the long-term plan for development. And we should be aware, what does that entail? So that brings us to actually what intergenerational rights are. Intergenerational rights are actually ethical imperative. And this is taken from the World Conservation Strategy, which actually shapes the narrative around issues of long-term planning and also future generations, but also current generations, actually young newborn children. So we don't inherit the planet and Earth and resources from our parents, we borrow it from our children. So that is quite important notion to bear in mind when making decisions on development, environmental protection, and generally human rights. Now we will move to because we are slowly moving into the issues of the legal and policy frameworks. I would like to make just clarification, what are the functions of law and what is the purpose of the legal and policy framework, especially international one and EU one, on intergenerational rights, rights of the child, and environment. So law has basically 3 functions: to command, to prohibit, and then the third one is to actually empower. We have now, since the mid-20th century, we have the function of law as an empowerment one. That's actually the new development, especially within the international law. And that we also need to bear in mind, which brings us to the next one, that only in a community law can have a basis other than law. And this actually brings us to the EU law, because EU is community law. EU is a significant actor in the field of the rights of the child and environment, and as a critical actor, it has a significant role in ensuring that children and environment are protected, not only within the EU, but also through the development cooperation and assistance outside of the 28 member states. Now we will go to look into the international framework on children and environment, including the issues of climate change. I kind of made two separate frameworks because in international law, there is no human rights treaty that articulates or actually explicitly recognize the environmental rights or human rights related to environment, but those rights are actually derived from other rights. So we have the Universal Declaration, International Covenant of Civil Political Rights. In the context of the rights of the child, certainly the Convention of the Rights of the Child is the most important in that regard, because it articulates the rights of children, and it has almost the universal ratification. And in that regard, I also put the European Convention of Human Rights, because the practice, or actually the case law of the European Court for Human Rights in regards to protection of environment is quite significant. And then we have also overlaps between the case law of the European Court for Human Rights and then Court of Justice. And then we also have the environmental law treaties, environmental and climate change. We have a proliferation of environmental law, and it would be quite extensive exercise to list all of them, but I actually only listed those that are most relevant in the context, not relevant, but they're most applicable in that regard when it comes to children and environment. For instance, Paris Agreement is quite important in that regard, because in 2021, the United Nations Committee on the Rights of the Child actually had a ruling they had a ruling based on the communication procedure, that they found that actually member states who increase their that member states, or actually in question, are responsible for the negative impact of its carbon emission on children's rights, both within their territories and outside of their territories. And that was actually based on the Paris Agreement. And now we have a greater trend of actually connecting the rights of the child and the Paris Agreement in terms of following the content of the protection of children's rights in relation to climate change. And here it's quite important, and in that regard, Paris Agreement represents a milestone, because now we have a baseline to judge whether the human rights and rights of the child are derogated based on the baseline set by the Paris Agreement. This brings us to the sources of law in the European Union. I just listed the general one, because we will discuss it more if you would like on the specific articles and implications. Apologies. So when we talk about the environment, intergenerational justice, and environment, we need to consider what kind of impact have environment on environmental degradation on children. And we can see that environmental degradation that manifests itself as pollution, climate change, and energy poverty can have significant impact on children's life, survival, development. Here I would like to stress out that the right to development that I'm mentioning from the Convention of the Rights of the Child is not the same the right to development from the Declaration of the Right to Development, but it's the one that actually allows children to fully reach the age of majority, and that they're actually able to access the services, but also benefits of the ecosystems in that regard. So we have the issues of pollution, which ranges from air pollution to water, soil, but also pollution in cosmetics, food, and etc. Because especially within the EU, there is an increasing concern regarding the endocrine disruptive chemicals in cosmetics for children, in their toys, and etc. We have issues with the climate change. Climate change also severely impacts the the basic rights of children and impact the quality of life. And of course, we have the energy poverty, which is becoming more and more prominent. So basically, those are the issues from, again, pollution from using unclean cooking facilities, which is not that much of the issue within the EU, but the issues of cooling and heating is actually becoming more increased issue, and also the issue of mold in the households, not only in the households, but also in the educational institutions. And there are also other issues related to energy efficiency within the buildings and schools and etc. Then we have environmental degradation impacting specific rights of the child. I here just listed some of the main rights that are more evident and the most critical ones. I'm not saying that there is hierarchy between rights, but those are rights actually if you don't. Right to life, survival and development is critical, because without that right, any other right is not possible to be achieved. So right to life, survival and development is severely impacted by environmental degradation. We can see also that especially for children under the age of 5 more times greater morbidity on the same environmental borne diseases. Right to health is also severely impacted from increased number of children with obesity, asthma. You have a diverse range of issues related to right to health and environmental degradation that comes, again, right to an adequate standard of life and housing, related to energy poverty and not being able to access the modern energy services. How the best interest of child is often one of the rights actually frequently violated, especially in the balancing exercise between the different aspects of development, right to education, etc. As I said, the Convention of the Rights of the Child does not have explicit reference to right to environment as such, although it actually didn't get into the convention, although we had in the 80s discussions of children having the right to adequate environment, healthy, safe, sound, with different characteristics, but essentially to have an environment of a certain quality that will actually enable their life survival and development, because whatever we do, environment is condition sine qua non, and essentially if we don't have a life supporting system, nothing else is actually possible to do. And then now it's giving a bit different perspective of environmental rights. So we, within the context of rights of the child, environment, and generally human rights, we have both procedural rights, so access to information, participation, access to justice, and those are basically the procedural rights from the Aarhus Convention. Here I would also like to mention that while it seems quite beneficial to have these rights, there are many actually challenges in implementing these rights. For instance, and it also relates to the different understanding and interpretation of the obligations, particularly of the states in regards to accessing information. For instance, the human rights law, rights of the child law, but also environmental law. For states, actually, on states impose different kinds of obligations. We have positive obligations, so they're ordering state to do something. Then we have negative obligations, ordering state to prohibit state from doing something. And then we have also two quite important obligations, which are the obligations of the conduct. So ordering state how to behave, and then obligation of result. Within the, for instance, access to information, there are quite a bit challenges in implementing that right, because there is always a question whether the access to information is obligation of the conduct or obligation of the result, especially in environmental matters and environmental health issues. Because sometimes if we have a, let's say, narrow interpretation of the access to information as obligation of the conduct. That means that the information can be published, but important aspects of that information can be omitted due to, let's say, labeling that information as, for instance, commercially sensitive. While if we have access to information as something that is obligation of the result, then it needs to be fully published. This is particularly important in the process that we will mention later, such as the environmental impact assessment, but also applying the precautionary principle. Moving further, we also have the so-called substantial rights. Substantial rights, basically right to adequate environment, which is not fully, there is no actually shared understanding what is actually meant by adequate environment, health, sound, sustainable, right to water, right to food, right to access to energy. When it comes to right to adequate environment, as I said, that right is derogated from other rights. So we have, for instance, both the European Court for Human Rights in their judgments protecting the environment through other rights. We also had some relevant judgments of the Court of Justice. But also we have the practice that majority of the EU member states have a constitutional right to environment. So we can see that there is no unified approach to understanding or actually addressing the right to environment and the impact of the adverse impact of environmental degradation and development activities on children and their health, well-being, and generally rights. This is also the issue of then conservation versus innovation, because like with the present and the future, there, on one hand, you would like to preserve life-supporting systems, and then on the other hand, you would like to have, or actually we would like to have progress and developments that actually manifest as through innovations, but then we always have that uncertainty in how that will impact the environment and the rights of the child. And that actually brings us to the issues of environmental impact assessment, rights of the child impact assessment, and precautionary principle. Because given the recognition of these links and the potential long-term implication for children's rights, we now see that there is also growing consensus among scholars, policymakers in addressing the environmental degradation, not only as an environmental imperative, but also as a human rights imperative, rights of the child imperative. We also have the documents of the UN human rights bodies, specifically articulating that environmental issues and climate change issues are rights of the child issues, but still we have significant challenges in addressing and protecting both of those. Nevertheless, the European Union has been at the forefront of promoting the children's rights and recognizing the interrelationship between environmental degradation and rights of the child. And it also demonstrates a commitment to protecting environmental rights through various legal instruments and policy initiatives. And it's also been integrated into the international cooperation and assistance. When it comes to environmental impact assessment procedures, it's guaranteed environmental protection and transparency with regards to decision-making processes for public and private projects. With its wide scope and broad purpose, it ensures that actual environmental concerns are considered from the beginning of development, big infrastructural projects, their changes and extensions. An important aspect in that regard is that it allows public to actively engage in environmental impact assessment. From the perspective of the rights of the child and intergenerational justice, it's been quite challenging to involve children to participate in environmental impact assessment for several reasons. But anyway, under the EU Environmental Impact Assessment Directive, Major building and development projects in the EU must first be assessed for their impact on the environment. And this includes projects such as nuclear power stations, railways, motorways, roads, waste disposals, and etc. And then we have also urban and industrial development projects and similar, which are actually, the environmental impact assessment is actually within the EU member states' decision to decide whether they will take environmental impact assessment or not. But anyway, the impact assessment actually assess the direct and indirect significant impact of a project based on a wide range of environmental factors, but also human rights factors such as population, human health, biodiversity, water, air, climate, material assets, cultural heritage, and etc. And there are also quite strict public rules, actually, how is public informed on the project, and how public can actually participate in decision-making processes, which can pose a significant challenge for involving children and generally young people in those processes. And of course, how is the public informed afterwards in the decision, after the decision was made. Then the next issue is actually the precautionary principle, which is actually detailed in the Article 181 of the Treaty of Functioning of the European Union, and it aims at ensuring a higher level of environmental protection to preventive decision taking in case of risk. However, with the precautionary principle, there are significant challenges in practice. Nevertheless, the scope of principle is quite wide, and it covers quite wide range of policies, including the consumer policies. And so one of the main challenges in applying the precautionary principle is actually when there is a scientific uncertainty, is also the interpretation that is applied in the case. For instance, do we actually pay attention to immediate danger or demonstrated risk? There are also issues regarding the burden of proof, but also issues related to extraterritorial application and how does it impact. Sorry. And then it comes to the rights of the child generally, and how we actually in formulation of the new policies and implementation and evaluation of the policies, how do we take into account children's increased vulnerability to environmental degradation? And here, maybe I would just like to emphasize the need to change the standard of setting the levels of environmental standards to be, instead of the average person, average child, because with the standard of average person, we are immediately discriminating against the children, because children are more prone to health issues and rights violation due to environmental degradation than the average person. So that would be quite important standard to be changed and to be taken into account, because like with the protection of children, we would significantly reduce the mortality, we would significantly reduce the health issues and quality of life and well-being. But then, of course, we have that issue of balancing different interests of different age cohorts. And just again, I would like to emphasize here, it's not a question of whether children's rights are more important than the rights of adults. It's more about, if we recognize the vulnerability of children due to environmental degradations, we have, both as individuals, but also as a community and collective, certain rights, actually obligations toward children that arise from their vulnerability. Challenges. just a quick question. How much time do I have left? I kind of lost track of...
Yes, I mean, I think you can have 5 more minutes if that is enough, or I mean,
okay,
we can be a little bit more flexible if you have a lot to say. It's very interesting, I must admit, so go on, please, and we'll see, yes.
Thank you. So I will then try to be quite quick here. So we have different challenges for the implementation of protection of the rights of the child, environment, development, climate change within the EU, although the EU definitely has been the most progressive and leader in that regard. So within the policy coherence integration, we have the fragmentation of the policy areas. This fragmentation is something that is common for not only EU, but the whole international law. So environmental issues, because environmental issues span across multiple sectors, agriculture, energy, transport, industry, it's kind of hard to make the coherence of the different policies and to take different environmental consideration and also the impact on rights of the child into account. And but one of the dangers of fragmentation of law and policy is actually that leads to conflicting objectives. And then these conflicting objectives result in inadequate environmental protection on one hand and violations of the rights on the other hand. Then, as I said, conflicting priorities. Here we have different conflicting priorities. We have on one hand economic development, social development, environmental protection, and the balancing exercise has been quite challenging, and we see that how different perspectives and understandings of development and priorities shape different decisions and outcomes, and ultimately result in the rise of criminality, violations of rights, and etc. Then we also have the issues of like cross-sectoral collaboration, which is closely related to the fragmentation of the law and policy. And one of the greatest challenges is actually inconsistent implementation. Because on one hand, we have the standards, but on the other hand, the member states have autonomy in implementing those. And then that can lead to inconsistencies in implementation of the rights of the child and environmental standards. And the final challenge is actually addressing emerging challenges such as the climate change impact and environmental health risks, because we don't know in advance what's going to happen. So we cannot plan accordingly, and sometimes we are quite surprised what can happen. And yes, participation and awareness, as I already mentioned, we have, especially when it comes to children, generally with the general public, there is not a lot of awareness how those rights can be protected, how environment can be protected. There is also a lot of challenges with people feeling discouraged, not being able to access remedies for environmental protection and rights, and etc., which can lead to lethargy and strengthening the institutional barriers, and generally result in engagement fatigue. But then let's move on to the more positive aspect. So strengthening the legal and policy frameworks, how we can actually more work together, how we can balance different interests. That requires also a lot of identifying different assumptions, underlying assumptions in decision making, and also stimulating the discussions of the implementation, but also focusing on the different actors other than states in the implementation or in the protection of environment and rights of the child. That includes international organization, it includes transnational corporations, investment and trade dispute mechanisms, civil society organizations, individuals, and etc. Then quite critical is integration of the rights of the child, environment, and climate change laws and policies. We're getting better and better at it, but more focused efforts would be quite beneficial for everyone, so we can see how it actually works in practice, and being flexible enough to to see what is working, what is not working, and also how different policies and integration initiatives can have different outcomes in different contexts. Of course, advancing access to justice, not only to courts, but also regarding the administrative procedures, especially strengthening the role of the national human rights institutions for protection of environmental rights. And of course, leveraging technological innovations to find innovative, sustainable solutions to challenges of environmental degradation, climate change, and generally development. Thank you for your attention. I can't hear.
Yes, sorry about that. So I start over. Thank you so much for your presentation. It was really interesting and provided a really good overview of the framework for intergenerational and children rights and then the environmental aspects of the discussion. So for our live audience, anyone who has questions, they can post them either in Zoom or on our YouTube channel in the comments section. In the meantime, we also have some other platforms from our institute, and I have a couple of questions there. Let me see something. So, referring to the rights delving from the Aarhus Convention, let's say rights like access to information, procedural rights, access to justice or participation. So I note that you said that when we were talking about children's rights, it's not about that they are more important than other people's rights. For example, let's say in this situation, indigenous peoples, let's say, but it's that the obligation that rise actually from children's vulnerability. So do you see that these rights of access to, for example, of participation or access to information, do you see them materializing from the channels we already have in multilateral environmental agreements, like youth groups or participatory in that way, or do we need some form of decision-making prospect in those children to realize those rights, you think?
I mean, there are a lot of institutional barriers because, as I said, we have children perceived as vulnerable and dependent, and that raises certain rights and obligations, right? When it comes to children participation in multilateral forum, we have actually institutional barriers in that regard because children who are below the age of 16 needs to go there with chaperone, which then brings us to the issue of organizing the children's participation. Like it also comes to how do you translate and make it more relevant with the technical discussions so they can understand and engage, because participation is not given, you just practice it. And those people who are already participating, they prepare for the participation in those processes for years and years. And equality in participation does not mean that they're just there. You need to create an enabling environment for them to make a valuable contribution, because they can make contribution. It's not to make it more, let's say, just decorative. So there are significant challenges in participation of children in international development. With young people, it's a bit different because once they reach age of majority, it's significantly easier for them. But then we have a lot of challenges in that regard. How do you balance protection and participation? And yes, and it's a bit sensitive topic because on one hand you would like to promote, and then on one other hand it can be quite exhausting. So finding a fine balance between those two can actually be quite beneficial, and then allowing them to actually have a voice, to practice how to make decisions, and learn how to be responsible for their decisions made.
Great. Ivana, if you can stop sharing your screen so that people can see us better.
Oh, sorry, I forgot about that.
Yeah, thank you. Thank you for this. Yes, I have another question here. It refers to something you said about different aspects of development and relevant concerns. So the question goes around the dichotomy between developed and developing countries and all these concerns. So would you think there is a case where, For example, we have environmental children rights, environmental related children rights on the one hand, and then more economic development children rights again on the other hand. Do you think that they could lead to different pathways of even theoretical discussion on the issue, let alone different policies? Because I guess that probably can lead to different policies.
Well, I see it more in the context of life supporting systems, because environmental economic development should be in favor of the life supporting systems. But if you don't have physical preconditions, because we're still living in the physical world, without those preconditions, it doesn't make any sense to talk about the economic. And we do have, especially in developing countries, a lot of issues regarding the economic development and children. One of the examples being the children's working in sweatshops that pose serious health, environmental hazards, and etc. And then we also have challenges regarding the so-called structural adjustments from international financial institutions. So that's where actually we need to work more on integrating those aspects, because sometimes the links are not so visible. When it comes, for instance, if we talk about the extractive industries and minings, children, although not working in the mines, are still, their health is severely impacted because their parents work in the mines, because they don't come home clean and they bring the toxicants into the household. So those are the links that needs to be recognized and addressed. And for that, we need also quite extensive scientific research, because without the scientific research and information, it doesn't exist, because everything is now more evidence-based. So we need to make explicit link between those issues. But yeah, more focus should be also on developing countries, how they can actually develop without degrading the environment and children's health rights, life survival and development.
Yes, thank you for your answer. And one last question I have here, it refers to the rights of the child impact assessment. I mean, today, environmental impact assessments, there is a lot of discussion about their quality and how they are done and how they're performed and who is monitoring and everything else. But the environmental impact assessments as such, they are quite mainstream. I mean, in the discussion we have about almost every project. Do you predict, do you see like such right of the child impact assessments entering our considerations in the near future, or would we have to wait for something like that?
Well, I think following the practices of the Committee on the Rights of the Child now, especially with the development of the general comment on the children's environment and climate change, I think it's going to become a standard soon. Maybe it won't be in the form of environmental rights of the child impact assessment as such, but we will see how actually the rights of the child will impact the environmental impact assessment, because within the EU, it's already considered the implications on the children's rights, etc. But here, I think it would be quite important to clarify, and I think that would be good from the Committee of the Rights of the Child to clarify what are the expectations of the states in implementing the environmental impact assessment. How is best interest of the child integrating into the environmental impact assessment and balancing different interests? So it doesn't have to be necessarily a new process that will burden, because you still want to have flexible, some sort of process where it's not burdened with additional challenges. But maybe restructuring, not restructuring, but reformulating, rethinking the current impact assessments to take more into account the environmental rights and also obligations of the states regarding the respect, fulfillment, and protection of the rights of the child, both within the territory of the state and outside, because that's also quite important aspect of environment because of the transboundary pollutions and environmental degradation.
Great, thank you. No, I know I said that it was the last one, but actually we have a question popping up in our chat from Chiara, and let's go with it. It actually gives us a very good pass to move to our second presentation. So it relates to the climate change discussion, environmental rights under the climate change discussion and under the Paris Agreement. And the question goes like, we see an increasing number of cases where children take their own governments to court for failing to meet their obligations. Do you think that this is an effective strategy for securing their rights? Do you expect more of this? How do you think this is going?
I expect that to be more in the near future, because before the Committee on the Rights of the Child, with under the special procedures, we had that's quite important ruling of the Committee on the Rights of the Child that actually found that the states are held responsible for the adverse impact of the emissions for their emissions in regards to children, violation of children within their territory and outside. And I think it can be quite good approach, especially because it raises awareness of the issues, and also it's also one of the duties actually of children themselves to practice protection of environment and development. And I think we should also consider, because how it's framed now, it's not clear what it actually means in practice and how it's relevant. And with those case law and judgments before the courts or administrative bodies or international fora, it's quite important to exercise those and change effectively the laws that are not working in our favor anymore.
Great. Thank you so much, Ivana. So we'll move on to the second part of the presentation. If you can stay around in case someone has any additional questions, we'll address them at the end.
With pleasure.
I would like to welcome our friend Manos Kalaitzis, who is on the other screen now, and I was saying that actually this gave us a very good path to move towards the second part of our presentation, because we discussed all this climate change law, and Ivana told us that the Paris Agreement could act as a benchmark for intergenerational rights, including children's rights and stuff like that. So the second part of our discussion will focus on the jurisprudence of the climate crisis in the Constitutional and Supreme Courts and the European Court of Human Rights. It will analyze how intergenerational concerns over equity can be incorporated in this legal process and what the future will bring us. So this part of the project, we have two contributors. Today, we will have one presenter, and that one presenter that we are very happy to have with us is Emmanuel, or Manos, as we would say colloquially in Greek, Kalaitzis. And we're very happy to also have Manos' expertise with us today. So Manos has a law degree from the Aristotle University of Thessaloniki, and he also holds a degree from the International Hellenic University on transnational and European commercial law and arbitration, as well as the Democritus University of Thrace on public international law. He also has studied in the KU Leiden on public international and European law, and he's currently a student at the National School of Judiciary. He has been an administrative and research assistant for UNESCO, and he's also been an expert at the European Economic and Social Committee, and was also employed at the European Parliament as a policy advisor on constitutional and citizens' affairs. So Manos will be focusing on climate change jurisprudence, and we are very much looking forward to hearing from him. Manos, the floor is yours.
Thank you very much. Thank you very much for the invitation, both you and the Institute. I would like now to proceed with sharing my screen. I must admit that I will do my best to follow Ivana's presentation, but I'm afraid mine won't be as creative as hers and as informative as hers. And I'm really, I have to admit that I'm really proud to join this panel along her and her expertise. So what I will try and attempt to examine during this presentation is the intergenerational justice as an emerging concept through the lens of international Supreme Courts. Delving into the topic, I wanted to have a starting point, this very monumental Human Rights Council resolution that was adopted not very long ago, that proclaimed the right to a safe, clean, healthy, and sustainable environment as a human right that is important for the enjoyment of human rights. Of course, as you might already know, this is a political declaration. This is a resolution that bears no legal obligation for the member states. Nonetheless, it does not lack importance, significance, and magnitude. So the right to a clean environment, though, has been traced in other instruments that were also mentioned by Ivana. So we can see the Aarhus Convention in a preambulatory clause. There's a reference to the right to live in an environment adequate to his or her health and well-being. The Aarhus Convention, though, contains mainly procedural obligations towards the states. We have other regional instruments for human rights protection that contain also stipulations of the right to an environment, as the African Charter of Human and People's Rights, which is a very progressive instrument, the Arab Charter of Human Rights, and the Protocol of San Salvador, which is a protocol to the Inter-American Convention on Human Rights. So the right to a healthy environment is stipulated more or less or elements of it, we could say, in 156 out of the 193 constitutions of the member states of the UN. So that makes it more than 80% of the member states of the UN. They have at least some aspects of the right to the environment. In the Greek constitution, we have Article 24. Now, when it comes to the European Union, we have the Charter on Fundamental Rights, where we have a general proclamation, we could say. I mean, we haven't seen this very much adjudicated in the Court of Justice of the EU. Though it is there, it is Article 37, which includes that the member states shall strive to integrate a high level of environmental protection and the improvement of the quality of environment into the policy of the Union. The European Parliament very recently, in June 2021, which was an initiative report concerning a commentary by the body on the biodiversity strategy for 2030, considers that the right to a healthy environment should be recognized in the EU Charter, and that the EU should take a lead on the international recognition of such a right. So we also have Article 191, 191, as also Ivana said, which includes the objectives to preserve, protect, and improve the quality of the environment, and of course the precautionary principle. In the European Convention on Human Rights, surprisingly, there is no recognition to the right of a healthy environment. Of course, that is this can be understood if we go back to the Travaux Préparatoires, and we see that the convention that was drafted back in the 50s, it clearly mirrored understanding of the rights that was mainly focused on civil and political rights, and of course social rights, such as the right to education, were added later on through protocols. And this is exactly why the Parliamentary Assembly of the Council of Europe in 2021 recommended the drafting of an additional protocol in this respect to include and protect the environment. So I believe that it's quite interesting to look into some of the most prominent cases of the European Court of Human Rights, because it's one of the most prominent regional institutions, courts, but also at the same time, it has been, let's say, slow in realizing and recognizing and stipulating the emancipation of the right to a healthy environment without having to go through the prism of other rights. So, as it was stated in the very well-known by now Heathrow case, or as it's officially known, the Hatton and others versus the United Kingdom, where people living near the Heathrow airport complained about the noise pollution and the decision of the administration to expand the airport. There is no explicit right in the convention to a clean and quiet environment, but where an individual is directed and seriously affected by noise or other pollution, an issue may arise under Article 8, which protects family and private life. In another case that I've singled out, which is the Greek case, Kirtatos versus Greece, here we have two building permits in the Syros Island. The Supreme Administrative Court quashed them, but the Greek state refused to comply. Basically, this was a ruling that hovered around Article 6, which is the right to fair trial. And the court also said that where a general deterioration of the environment is not sufficient, neither Article 8 nor any other provision of the convention is specifically designed to provide general protection of the environment. So it didn't accept that there was a violation under Article 8, only under Article 6. In the last case that I have included here, which is Hammer versus Belgium, again, the court stipulated that while none of the articles of the convention is designed to provide general protection, in today's society, the protection of the environment is increasingly important. It is an increasingly important consideration. So we see a slow but steady shift towards increasing the scope of the protection. So to summarize the basic points of the case law of the European Court of Human Rights, so where do we stand at the moment? Basically what the court has accepted generally, in principle, and in theory, meaning that in legal theory, you can have the responsibility of the state from omissions, not only from actions. So we might have the omission of the state organs, for example, to legislate, or for the judiciary to adjudicate, or the administrative authorities to take administrative measures. So that is to be taken for granted. That is a general principle. In Cordella and others versus Italy, where the Taranto and neighboring towns were endangered by the steel producing activity, the court accepted that the high environmental risk of people near the plant for decades, along with the Deming data that this activity caused some kind of health degradation to the people that resided, the residents of the neighboring areas, amounted to a violation of Article 8. So this is an indicative case which gives us exactly the understanding that here the court usually weighs the gravity ad hoc in order to see and accept that there has been an interference with the right. And basically that is done through Article 8, which is the right to private and family life, and Article 2, which is the right to life. The court has also accepted the precautionary principle. Here, indicatively, I have included this case. So where there are threats of serious or irreversible damage, a lack of full scientific certainty shall not be used as a reason for postponing cost-effective measures to prevent environmental degradation. So generally, Article 8 is the one that is the most usually invoked, and it may apply in environmental cases where the pollution is directly caused by the state, or where the state's responsibility arises from the failure to regulate private industry properly. So we have two options: either the state fails, causes pollution itself, or it fails to regulate. So here it is either analyzed as a pure positive duty or negative obligations, and it can be it can amount to an interference, and it has to be justified, and can be justified through paragraph 2. Of course, the court accepts a certain margin of appreciation and a fair balance between competing interests, individuals, and the community. This is based on the perception that the economic activity and development somehow is a competing interest as compared to the right to enjoy a private life away from any environmental degradation of the individual, which is, if I may say, an obsolete view of this fair balance that has to be attained. So most recently, I singled out this case, the case of Kotov and others versus Russia, not but because it has very interesting facts. I will shortly mention them, but because there is a dissenting opinion which really stood out. And I truly hope and I truly believe, because we have seen that in the case law of the European Court of Human Rights, that minority opinions, dissenting opinions, as we say, tend to be the future majorities. So what happened in this case? The 10 applicants live in a town in Russia near a quarry, which has been used as a landfill. And of course, the local authorities didn't manage it properly, or didn't regulate the activities of the private company that was managing it, which resulted to large amounts of solid waste being deposited there without the control or any protective measures. And that amounted to a violation of Article 8. So the dissenting opinion of Judge Serkidis, the cyber judge, says that since all human rights are interrelated and interdependent, they shall be viewed as being vulnerable to environmental degradation. So the full enjoyment of their human rights depends, of course, on the supportive environment. He sees also the right to a healthy environment as a sub-right of Article 8, as an implied or implicit, or as he puts it, as an emergent human right, which means that we're not there yet. And it could lead to also positive, both positive and negative obligations. He envisioned this legal construction as this article having ancillary or secondary nature. Compared to other instruments, this is still not satisfactory, but I found it to be still progressive comparing to the case law of the European Court of Human Rights. So what is the status quo at the moment? So there's no doubt that the convention does not entail a right to the environment to be protected, but at the same time, degradation of the environment could amount to a violation of a specific right recognized by the convention. So to summarize the case law, it establishes that where acts of physical pollution attain a certain level of severity, to the extent that there's an actual interference with the applicant's private sphere, the application of the convention is triggered and a violation might be found. So one might wonder, where does the intergenerational justice fit into all this? So the classic perception of equality demands that similar situations to be treated in a similar manner. This is grosso modo, this is framed in a very general manner, and the similar situations to be treated in a dissimilar manner. So discrimination can occur when a general policy has an effect that is disproportionately prejudicial on a particular group, even without the intention to discriminate. In this perception of the principle of equality, because when we're speaking about intergenerational justice, we're speaking about intergenerational equity. So we're trying to take this notion and see whether it fits into, whether we can fit it into the classic perception of the right of equality. So in the classic perception of the principle of equality, of the right to equality, the right not to be discriminated, there's this strong temporal element. In order to engage, to see whether we have a violation, we have to make a comparison, and we have to picture the situations right here and now. But when we're speaking about intergenerational equity, we are moving between generations. So can we perceive equality in an intertemporal manner, meaning through time? Could that include people that are not yet born? And when we're speaking about intergenerational justice and the right to an environment, of course, there is a strong transboundary element. So can we imagine this principle of equality disengaged from borders to include, to induce obligations on states that are not bound to their national borders? And what kind of obligations? Are we talking about positive, negative obligations, obligations of result maybe? And if we opt for the third, then can we set a time limit until which generation? When and how can we achieve an equitable result? So the European Court of Human Rights has previously considered age as a relevant ground for discrimination. One might say that while children are vulnerable to climate harm today due to young age, they will also be increasingly impacted by the latent effect of current emissions throughout their lives. They will have to suffer for longer than the current generation. They will have to suffer for longer with the effects, the accumulated effects of the climate change. So it is therefore not necessarily their age as of today that creates this long-term disparate impact, but more precisely the generation or birth of cohort to which they belong. But again, what about future generations? Is it possible to conceive the intergenerational elements? And how exactly do we define a generation? Approaching it through different sciences, through different fields of expertise, we can see that there's a volatility of the concept. So birth cohort as a basis of discrimination is not yet recognized. But is this intergenerational equity or intergenerational justice a new concept? No, it's not. Is the very short answer. We have seen philosophical depictions of the concept. Most notably, one of my most favorite pieces is The Tragedy of the Commons by Garrett Hardin. It's yeah, well, it has a few. I'm not a philosopher myself, but there are a few gaps in the thought there, and one can say that does not include a positive outlook of the future. But all in all, it has some arguments that are pertinent until today. So ruin is the destination towards which all men rush. Each pursues his own best interest in a society that believes in the freedom of the commons. Freedom in the commons brings ruins to all. Commons, of course, we can include in the definition of commons, the environment, or in general resources. The limits of growth from the Club of Rome report, from a report from the Club of Rome in the 1972, which spoke about the global equilibrium, is again another depiction of this concept. So is the Governing the Commons by Eleanor Ostrom. She stipulated the rules for the management of the commons depending on their nature. And very, very recently, The Good Ancestor by Roman Gnardev in 2020. This is maybe the most interesting work, because as we will see later on, it was utilized by decision of the National Supreme Court. So as this author stipulates, shooting an arrow into the distant wood ends up hurting someone, while someone could have been there, amounts to gross negligence. So he says we have to take responsibility and act today to mitigate future impacts of the arrows we fire. Intergenerational justice has been invoked also during the economic crisis in order to argue against austerity. Kind of an intergenerational justice was invoked during the accession of Poland to the Union. Those are a few examples that popped into my mind when preparing this presentation. In order to gain seats in the parliament, I mean, referring to the population that would have been prior to World War II and that population that it has today after the war. Indigenous peoples and their ancestral rights to their lands, of course, is another depiction of intergenerational justice. And the Cultural Heritage Conventions, the preservation, which stipulate the preservation of the cultural heritage, man-made and natural for the future generations. So here we see Article 4 of the World Heritage Convention of the 1972, which again says protection, conservation, presentation, and transmission to future generations of the culture and natural heritage. So the European Court of Justice has, there are a few traces in its case law, not relating to the environment, although I singled out 3 cases which dealt basically to the principle of non-discrimination and social rights, pension age, and the access to employment. Until now, the court has not utilized this concept more broadly. Obligations to future generations are to be found as well in some of the national constitutions and, of course, national and subnational legislations of many countries. When it comes to the environment, we can see we have, of course, the UN Framework Convention in Article 3, where we see a very full-fledged stipulation of the principle. We have the Statute of the Council of Europe, the UN Charter, the SDGs, of course, the Principle of Sustainable Development also includes traces of that concept. In the International Court of Justice, in a separate opinion, Judge Trindade in the pulp mills case, which is a very important environmental case, argued that nowadays it can hardly be doubted an acknowledgement of intergenerational equity forms part of conventional wisdom in international environmental law. So the question that we have to answer after having examined all of the above is, can we litigate based on intergenerational justice? So we have to see now we'll see a few of the most important cases, climate change cases that came before the courts, basically starting from the national courts. and later on moving to regional and international. So in the Urgenda case, the Dutch Court of Appeal and the Supreme Court ordered the Dutch state to reduce the emission of the greenhouse gases by 25% in 2020 compared to the emissions in 1990. So this is the first case. The litigation started 2015, ended 2019. It had a huge impact, and it acted as an inspiration for other climate change litigations. So no reference was made to the future generations. The court decided that climate change presents a threat to the current generation, and it based its judgment on Article 2 and 8 of the European Convention on Human Rights. Milieu Defensie versus Royal Dutch Shell, also another Dutch case where the court accepted the duty to care, again based on Article 2 and 8. And here it stated that the emissions by their nature pose a very serious threat with serious impacts, and this applies to both current and future generations. Other cases include the Neubauer by the German Constitutional Court, where the Bundesverfassungsgericht decided that the basic law, German constitution, encompasses the duty to protect life and health against the risks posed by climate change, and it can furthermore give rise to an objective duty to protect future generations. So it decided that the climate law, the German climate law at the time, violates constitutional freedoms of the future generations. So in Norway, in 2020, of course, this was a case that was not successful. Following the reasoning of the European Court of Human Rights, it did not, of course, it accepted that measures should be implemented to contribute and to secure a healthy environment for current and future generations. But following a very strict application of the division of powers, it considered that such considerations, such decisions lie with the government and the politicians that should take the decisions through the elected bodies. In Ireland, the Supreme Court rejected the implied judicial recognition of a right to a healthy environment, stating that the advantage of expressing cooperation is that the precise type of constitutional right to the environment which is to be recognized can be the subject of debate and democratic approval, again following the rationale of the Norwegian Supreme Court. Although it found that the plan that the government had drafted was excessively vague and aspirational, and too much is left for further study or investigation without pointing towards a specific direction for the government or any suggestions for them to implement. So in the United Kingdom, we have another case which is not yet decided. A few very prominent NGOs, environmental NGOs, challenged the inadequate efforts of the government to reduce emissions. So in July 2022, the High Court held that the government's plan was unlawful. It established that the government's strategy lacked legally required information, making it impossible to understand and to assess the risk of missing domestic mitigation goals. So the court also found that the parliament should oversee the implementation of this plan. This is another case as well in Czechia, which was brought by two farmers. The court emphasized, of course, that mitigation measures cannot be postponed because of the irreversible nature of climate change, and it ordered the government to up their efforts in order to meet the objectives for the reduction of emissions. So here the Klimaatsak, which is the case in Belgium, is the largest, the biggest environmental litigation worldwide, with many, many plaintiffs, as you can see, in the thousands. The court found that the citizens' rights were violated, but nonetheless, it did not order the Belgian state to reduce emissions. Therefore, there's an appeal pending. In France, of course, we have the very well-known by now cases, L'Affaire du siècle, where the Administrative Court of Paris recognized the legal responsibility of the French state for its contribution towards the climate crisis. And the Grand Sinthe, where the mayor and the municipality brought an action arguing again that the state failed to effectively reduce emissions. Both complainants made use of notions and concepts emanating from the intergenerational equity, but the court did not recognize them explicitly, it only utilized them tacitly. So, in order to conclude this round of European national courts, we can see that basically their rationale is built on their national constitutions or Article 2 or 8 of the European Court of Human Rights, and they conclude that those two articles require emissions cuts to avert dangerous repercussions. Some of them base their conclusions on aspects of environmental equity, environmental and climate democracy, and or intergenerational justice. Now, taking a step back and opening up our spectrum, I have here a few very, very interesting examples of how other Supreme Courts have reacted to the climate crisis that we're facing. So here, the Pakistani High Court, Lahore High Court, and I have to admit that it was such a pleasurable experience reading those cases, because I, as a future judge, as I'm now in the judiciary school, I really liked and enjoyed the fact that the High Court utilized in such an extent literature, the philosophical concepts and other concepts apart from the strict legal notions in order to address such a current topic. So here, the court, of course, accepted that the right to life in the national constitution includes the right to a healthy and clean environment, and of course, that the human dignity, the right to human dignity, read along with different constitutional principles, includes within their ambit inter and intergenerational equity and the public trust doctrine. Again, another more recent case of the Supreme Court of Pakistan, which dealt with a ban on industrial activity in the area of Punjab. So the company, the cement company, appealed and challenged the decision of the local government to order the cease and the ban of their activity. And of course, the court, with a very generous reasoning, said that the tragedy is that tomorrow's generations aren't here to challenge this pillaging of their inheritance. The great silent majority of the future generations is rendered powerless and needs a voice. This is the final, the concluding remarks, and therefore all contentions are to be rejected. Again, we have here a Nepalese case from the Supreme Court of Nepal, which accepted that only by embracing the principles of sustainable development and allied principle of intergenerational and intragenerational equity and formulate a law to conserve biodiversity and ecosystem, we can establish an edifice of climate justice for present and future generations. This was argued, and of course the court accepted it. I won't go into the details. Okay, of course, of the Canadian cases, because unfortunately the first two were not successful. The third one was successful, and it was the first time that the Canadian court recognized that climate change has the potential to violate human rights protected by the Canadian Charter, and the government can be ordered to take action on climate change. So it's not as progressive as the ones that we already saw. Here we have also a very interesting case in Colombia, where the Supreme Court accepted the petitions by very young people and children, and it ordered the government to make out and carry action plans to address deforestation in the Amazon. Of course, that has not yet taken place. So the plaintiffs in the case claim that intergenerational equity isn't only between the present and the future generation of people who do not yet exist, but also between those who make the decisions today and the generation of younger people who face the effects of those decisions made in the present. So the Supreme Court of Colombia applied the principle of intergenerational equity to future generations, including the children who brought this action. A case in New Zealand, of course, accepted that that there was a failure by the government, but did not order the government to take any action because there was a change in the administration. The new administration had voluntarily submitted itself into increasing their efforts. There was here that this was a request for an injunction that included mining activities, and the injunction was granted again based on the principle of intergenerational equity. This is a case that is pending in the Republic of Korea, where the Constitutional Court in Seoul will examine whether we can stipulate the principle of non-discrimination for children that were the applicants and plaintiffs in this very case. Again, another case that is still pending. Of course, this related to the negligence of the government to take measures to protect the islanders from the increase of the temperature. And this is the very famous Julian versus the US case, which was again one of the first, and it's still pending after the Ninth Circuit Court of Appeals that ruled that the plaintiffs lacked standing, since it adjudicated that this case was beyond the judicial power, again following the rationale of the Norwegian court, as we saw. Now, going back to Europe, there are a few pending cases before the European Court of Human Rights that I find that they are very interesting and present a unique opportunity when it comes to intergenerational justice. Those are the following: the Duarte Agostinho and others versus Portugal, and other states, 32 member states and state signatories to the European Convention of Human Rights. This is the very well-known Portuguese youth case. The Verein Klima Signorinen Schweiz and others versus the Swiss Confederation, and the Carême against versus France. So in all three cases, Chamber relinquished jurisdiction in favor of the Grand Chamber. In January 2023, there was a procedural meeting in the three aforementioned cases and decided to stagger the oral case, which means that it will hold different hearings in stages in order to examine all aspects of the particular case. And of course, it applied also Rule 41 of the court, giving it priority status, meaning that the court examined and accepted that those cases have a particular importance and urgency. Other cases were submitted before the European Court of Human Rights. I will not go into detail about the different cases because they were adjourned. The court decided to adjourn their examination of the 7 other cases that we saw. There were 2 more declared admissible, but it decided to adjourn until the Grand Chamber has ruled in the climate change cases that we saw, the 3 that we saw in the beginning. So in the climate ladies case against Switzerland, we have the other, let's say, aspect of the issue. Now, we don't have children as plaintiffs, but we have older women, the oldest of which were 80 at the time of the filing. Unfortunately, she's not longer with us. And it concerned the consequences of the global warming on their living conditions. The respondent, which was the Swiss Confederation, it was alleged that it failed to observe climate obligations. In particular, the climate change mitigation targets as they were set by different international treaties. So what was argued again, classically, traditionally based on Article 2 and Article 8 of the European Convention, the failure of the state to legislate and take administrative measures to provide effective protection against threats to their life and private life. Why? Because there are extreme heat waves in Switzerland that caused, of course, the average annual temperature to increase, which in turn caused the high mortality risk and related illnesses and, in certain cases, deaths. So the old ladies claimed the Article 8 as pertaining to the right to age in dignity, since they are in a significant reach of such temperature-related morbidity and mortality. The Swiss government, of course, rejected this petition as an actio popularis. They said that there is no victim status, they do not face an imminent risk, and there is no causal link between the government's omissions and the harm that they have suffered. Of course, the applicants presented many data and facts related to their claim. Many governments have intervened in this case. So, does this case present an opportunity, or are we staying with the status quo? My viewing, as I have examined the file and the relevant documents, that we're proceeding with the status quo. Here, the title of the A very clever title of an article that was published recently on the case. As I've seen it, the arguments are not building on the existing case law in a confident and convincing manner. There was much attention to the status of the victim in order to justify the admissibility, and also in theory, and also in the court's hearings, and the causal link between the environmental degradation. Of course, the admissibility and merits are intertwined. Nonetheless, it draws attention from the main issue. So the hearing has shown the difficulty of calculating Switzerland's remaining emissions budget and corresponding obligations for the reduction, which means that the court might not be able to calculate and quantify the emissions obligation. So this is clearly a missed opportunity. On the other hand, the Claudia Duarte Agostinho and others, the Portuguese youth case, as it is known, it is a signing opportunity for the court to make the turn and eventually accept and catch up with other regional courts and other supreme and constitutional courts around the globe. So the applicants allege a violation of Article 14 in combinations with Article 2 and 8, arguing that global warming affects their generation in particular, and that given their age, the interference with their rights is more pronounced than that with the rights of previous generations, in view also with deterioration of climate conditions, which will continue over time. Here, a very interesting fact is that the European Commission asked leave to intervene, and this was granted. I could not find the intervention in the amicus curiae that was filed, but that would be interesting. Now, when it comes to the Court of Justice of the European Union, there was an interesting case brought before it, the Armando Ferrao Carvalho and others versus the Parliament and the Council. This included the families, 10 families from and their children that came from small islands and other countries, member states, and they alleged that the EU's existing target to reduce emission is insufficient to avoid the dangerous climate change. This leads to a discrimination against the younger generations in favor of the older generations. Unfortunately, well, whilst this lawsuit had two major components, of course, first the nullification action against different legal acts, and secondly, there was a request, I believe, on the basis of non-contractual liability, Article 340 of TFEU, meaning that there was an unlawful act, and then a lawful act breached a right, and of course that is in a causal link with the breach, and it creates the non-contractual liability for damages to be paid. But at the first instance and the appeal, the General Court and the Court of Justice of the European Union dismissed the case on the grounds that they're not sufficiently and directly effective. So it was declared as inadmissible. In the Inter-American Court of Human Rights, we have a very important advisory opinion, which was requested by the Republic of Colombia regarding the environment and human rights and the state's obligation that arise under the San Salvador Protocol. Here, the court advocated that, of course, the human right to a healthy environment has been understood as a right that has both individual and also collective connotations, and is an important right that is very important and has a value for the existence of the humankind, and is owed to both present and future generations. In the International Court of Justice, very, very recently, namely in April 2023, the General Assembly of the UN requested an advisory opinion after the initiative of many island states in order to clarify which are the obligations of states under international law to ensure the protection of the climate systems and other parts of the environment from anthropogenic emissions of greenhouse gases for states and for present and future generations. This is a very monumental request that was submitted to the International Court of Justice. The same group of states submitted a request to the International Tribunal for the Law of the Sea, again formulating the question under the premises of the United Nations Convention on the Law of the Sea, and targeting the marine environment and marine pollution. A new request was submitted again in 2023 by Colombia and Chile in order to clarify further the previous and building on what was grounded in the previous advisory opinion in the context of the climate emergency, especially and in specific, given the specific emphasis on the individual and collective dimension of the obligations, and how the differentiated differentiated obligations of the states are to be viewed. So, concluding this very long and I hope not very tiring presentation, I reach my conclusions. So after having examined the jurisprudence and the case law of different courts, I believe that despite the fragmentation of the judicial approaches, we see a growing consensus in increasing the efforts towards strategic litigations, meaning people, meaning states, small island states that are taking the floor to enact cases and submit applications to different procedures. Despite, again, the fragmentation of the judicial approaches, we see a cross-fertilization of the different decisions. So we see courts building on each other, and that might have very fruitful outcomes. As it comes to the intergenerational justice and equity, I'm not certain and positive whether it will emerge as an independent concept, even ancillary on the basis of Article 14 of the European Convention of Human Rights and the principle of non-discrimination. But that is a difficult terrain. The European Convention of Human Rights is a difficult terrain, but even in other areas, we see I might not have a tangible outcome. What I see as the great opportunity, of course, we saw the Agostinho case of the European Court of Human Rights, which is one opportunity that the court, I think, will grasp. But also the advisory opinion of the International Court of Justice, I think, will provide surely a launching board for the emergence of the notion, and maybe clarification and at least some elucidation of its status under international law. Judge Staten writes in her dissent in the Juliana case that where is the hope in today's decision after having dismissed, of course, the application when the seas envelop our coastal cities, fires and droughts hunt our interiors, and storms ravage everything in between. Those remaining will ask, why did so many do so little? Well, that is a question that we have to take from this presentation. I believe that claimants and applicants will seek to rely upon this concept because regardless of whether we can conceptualize it as a legal obligation, intergenerational equity is a moral obligation, more or less, and it is also a source of hope. Thank you very much for your attention.
Thank you so much, Manos. This was really, really good. Yeah, I'm really impressed with all the overview of all the cases, and I must admit I don't have a legal background, but I really look forward to reading your paper with all the cases, especially some cases like that one from Pakistan that you mentioned, the recent one, the 2021 case from Pakistan, which I would say, I mean, as I said, I don't have a legal background, but it was a bit off the radar. And, you know, like those quotes like generations, what was it, are not here to challenge this pillaging of their inheritance, so stuff like that. I hope that, you know, more judges in the future can have such broad philosophical perspectives on things. But let me bring you to something that that you said before on the concept of intergenerational justice as applied to indigenous peoples. You mentioned briefly that in your presentation. If we take it that concept of justice and equity mainly looks towards the past, or the injustices towards these indigenous peoples that happened over the centuries and nowadays, of course, as well. Do you think we could develop something similar, let's say, looking to the future to address all these challenges we're dealing with for future generations?
Well, thank you very much for your question. Unfortunately, the concept of intergenerational justice as it comes to the indigenous people is a concept that emerged out of the suffrage and, of course, the huge and grave injustice that they suffered throughout the years and the colonial times. But as you understand, this is a concept that was the reason and was, of course, depicted in the declarations for the indigenous people and relates to their claims as it comes to their ancestral lands. So again, it has a huge element that relates to the past. So if we want to transpose that directly to the environmental cases, I don't believe that we will manage to find and build upon it as a fertile ground in order to breach the obligations of today's generations towards the future generations. Because the principle applied to indigenous people, it basically tries to bring an equilibrium of the status that people had back then to the viewing and the status and the rights that they have today. So again, we still are missing a link and an element in order to bridge it to the future. Certainly, it would be a starting point of, and as I told you, it is a depiction of the principle, and it shows that this is something that can be somehow depicted legally, but definitely it cannot be transposed as such to environmental cases.
Thank you so much. On a different note and building on this, you mentioned a little bit on the UN Convention on the Law of the Sea and stuff like that, and I would like to ask a question on a practical note on some of the law of the sea. So we have a rather peculiar case where we have some kind of non-national obligations in the respect that areas beyond national jurisdiction have certain resources, mainly mineral resources. Those are considered, according to the UN Convention on the Law of the Sea, as the common heritage of humankind. Yeah, and we're talking about minerals. We're talking about cobalt, we're talking about nickel, and some kind of rights and obligations arise as they are considered a common heritage of humankind. We're still trying to, you know, address what exactly are those obligations and those rights. But wouldn't you say that people that will exist on this planet as future generation in the future, wouldn't they have similar rights to the ones, or similar, not similar maybe, but wouldn't also they have rights in those resources as we do?
Of course, and when it comes to the area that, as we call the region that lies beyond national jurisdiction, That is the rationale behind the convention, the UN Convention, the Law of the Sea. But this is exactly why it has faced many difficulties being implemented. So that's why the authority that will deal with the management of the resources lying in the area is not yet operative. It's not yet functioning because all those considerations regarding how those resources should be managed, how they should be allocated, what is considered to be the development of the peoples, what is the interest that lie with the division, because in the 1980s there was still a huge debate between the division of the developing, the developed world, and how an international, let's say, more just allocation would be achieved. Of course, legally speaking, the obligations that arise from the 1982 Convention also include future generations. There is no time limit. There is no ratione temporis, let's say, limitation when it comes to the benefits that arise from this area. But exactly because it is so difficult to define, that's why we can only theorize about it, and we don't have any tangible outcomes other than, of course, proposals that were made by the International Tribunals on the Law of the Sea and different theoreticians. So unfortunately, we have to break theory of practice, which is, as you understand, when we have competing interests, is not very easy.
Absolutely, yes. Thank you for your response. And I have a last question that forwarded to us by one of the participants. It refers back to one of your original cases, one of the cases that you used in the start of your presentation. It was the Cordella and others versus Italy, the Taranto case. Yes, that is, I believe, a still producing case. Correct? So you were saying that the Article 8 was invoked, etc., and the gravity of the case led to an ad hoc decision on the matter. Do these things, I mean, and forgive my legal limited understanding of legal processes, does this lead to any legal precedents, and can these cases or some of these cases be used as a precedent in future cases in EU law, including in cases in Greece? Because our fifth and last seminar, and I would like to make this link towards the end of this seminar, is actually the challenges in practice, and we have had some challenges in practice. Do you think that any legal precedents are created and can be used in cases in national law, including in Greece?
Yes and no, I would say. So yes, of course, the Cordella case is still producing, and yes, the case law of the European Court of Human Rights is encompasses also the notion of jurisprudence, and of course, the European Court builds upon its cases. So usually it refers to findings in other cases, and definitely outcomes and results are utilized in adjudicating other applications brought before it. Now, when it comes to invoking such precedents, and I use quotation marks because the notion of precedent is not recognized in all, let's say, legal orders, and especially in the Greek one, we don't have such a notion. So the case can be utilized, but when it comes to the victim status, I would say, which is the legal interest to apply before a court, we have to have an administrative act that is pertaining to the environmental preservation, or at least some kind of order or giving leave or permission for a certain activity that might hamper the environment, or they are on the one hand, or some kind of omission of the state to act properly, that amounts to the interference with a certain right. But the threshold in those cases, at least in the Greek legal order, can be very high. So there's a demand that the link towards the case is very strong. So usually what the court, at least the Supreme Court in Greece, what it examines usually is either a link that brings the applicant closer to the case, either that is by location or that it directly affects him or her, which is a bit higher than what it is utilized in the European Court of Human Rights. So basically, to answer your question, yes, it can be used as a legal precedent, but I'm not sure whether, let's say, for example, coming to the mining activities in Greece, this could have led to a positive outcome. But again, exhausting national legal remedies gives us a leeway, an option to approach the European Court of Human Rights.
Great, thank you. We'll be in touch. Hopefully, you can contribute to our discussion in the last event that will also address some of these aspects. So, actually, thank you both very much. It was a great discussion, and I think it will contribute to the different aspects that we're trying to analyze through our project. The recording of the event will be available on YouTube, on our page on YouTube, and also on the project website, which is environmentalrights.eu. In that website, also all the research papers that all the participants in our project will contribute will also be there in English and in Greek. And I'm really looking forward to your contributions. It was a really good seminar today and really informative, also in aspects that I must admit I didn't have any deep knowledge about, and this is what it's all about. So thank you so much, and let's have our appointment for end June for climate change and biodiversity, discussing a little bit more in detail some of the litigation aspects or other aspects of climate change and environmental rights. Also, I thank you both very much for producing a little bit on a European perspective, which is quite important. As in the policy field, the EU region has been quite a proponent of the right to the environment, and future developments will the EU will play an important role in future developments in that respect. So thank you all again. Thank you to all our participants, and see you soon. Bye.
Goodbye.